Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, just last week, it was an exploratory campaign, but by this week, well, it's turned into a full-blown movement. By next week, he'll be anointed position of governor, and probably before the 4th of July, he'll be appointed as Supreme Chancellor and Emperor of the Galactic Empire. Who am I talking about? Well, of course, I'm talking about none other than your Attorney General Bob Ferguson in his quest for more power to become the governor of the state of Washington. But listen, I'm going to make some very bold statements here, and then I'm going to back it up with some evidence. It's not often that we do necessarily political hit pieces. I don't think this is a political hit piece, but I do think it's some stuff that you should all think about. So today, let's spend a few minutes and talk about when a tyrant wants to become governor. Okay, so the issue we're talking about today is Attorney General Bob Ferguson and his never-ending quest for more and more power as he now wants to become our next governor. In particular, what we're going to be doing, however, is talking about a case of Second Amendment Foundation v. Ferguson. Now, this is a case that was just filed in the Western District of Washington. It's gotten a little bit of publicity, and candidly, it should get a lot more. And I'm hopeful that what we disseminate here is going to get out so more and more people can understand who this individual is that wants to be our next governor. Now, as we state all the time here at Washington Gun Law, we do not want to necessarily tell anybody how to think. You're all big boys and girls. You can think for yourself. But we do want to give you all the stuff to think about. Now, I recognize that the title of today's presentation, When a Tyrant Wants to Become Governor, is pretty bold and brash. So, can we actually back it up? Well, let's first go to the Webster's Dictionary and let's figure out how tyrant is defined. It is defined as follows. Tyrant, noun, an absolute ruler unrestrained by law or constitution. A usurper of sovereignty. Okay. A ruler who exercises absolute power oppressively or brutally. One resembling an oppressive ruler in the harsh use of authority or power. So what we would have to do, I suppose, to be able to corroborate the title of today's presentation is to somehow or another demonstrate that Attorney General Ferguson has engaged in some type of oppressive and tyrannical behavior. Can that be done? Well, what I'm going to do is I'm going to read the first few paragraphs of this lawsuit so that you can understand what's going on. Now, I recognize this is going to be a much longer quote than what is normally put here on Washington Gun Law, but the pleadings are so well done, and it really, really gives you a flavor of what Mr. Gottlieb and everyone at the Second Amendment Foundation has had to endure at the hands of this Attorney General for the last several years. This is how the pleadings lay out the case against the Attorney General. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Our democratic system is built on this foundational rule. Every citizen may believe as her conscience dictates and advocate for political change corresponding to those beliefs. The right of citizens to inquire, to hear, to speak, and to use information to reach consensus is a precondition to enlightened self-government and a necessary means to protect it. This basic tenet sets the United States apart from repressive regimes in which the powers of office are used to suppress opposition. Official animosity to political speech offends the Constitution because it threatens to inhibit the exercise of these protected rights. The people of Washington entrusted Washington Attorney General Bob Ferguson and the attorneys beneath him with significant prosecutorial and investigatory powers so that they could fairly enforce the laws enacted by the people's elected representatives. But Mr. Ferguson and his colleagues have overreached. They have used their powers to target citizens who simply believe differently from Mr. Ferguson. The Washington Supreme Court recently held unanimously that Mr. Ferguson's office improperly used Washington Consumer Protection and Charitable Solicitation Acts to suppress constitutionally protected speech with which he disagreed. But Mr. Ferguson remains unrepentant, publicly stating that he is proud that his improper investigation chilled the exercise of constitutional rights. Mr. Ferguson's office has now set its sights on conservative activist Alan Gottlieb and a number of nonprofit and other entities he is associated with. Each of these entities is dedicated to causes with which Mr. Ferguson's office disagrees. Specifically, the Second Amendment Foundation and the Citizens Committee for the Right to Keep and Bear Arms are nonprofit organizations that advocate for civil rights related to self-defense, gun ownership, including by bringing litigation challenging laws they believe are unconstitutional, and by educating grassroots activists, the public, legislators, and the media. As a consequence of their constitutionally protected advocacy, Mr. Gottlieb and these entities, collectively the plaintiffs, often find themselves at odds with Mr. Ferguson's office. In particular, Mr. Ferguson has often been a vocal proponent of gun control measures, which have led the plaintiffs to clash with him in and out of the court. Regardless of one's views on gun control policy, this oppositional give and take is the cause and result of a healthy democracy. The plaintiff's advocacy facilitates the enactment of policy that accurately represents the will of an informed electorate, and their litigation ensures that the laws on the books comply with constitutional guarantees. But Mr. Ferguson's office does not see it that way. The CIDs demanded on penalty of legal action that the plaintiffs review and produce tens of thousands of pages of private documents and detailed written response to dozens of interrogatories, in some instances concerning events that happened over 40 years ago. CPD has already required Mr. Gottlieb to submit to a one-day-long deposition, and it has scheduled more, planning to take his testimony as a representative of SAF, CCRKBA, and SBA. It has repeatedly scheduled, postponed, and rescheduled additional depositions of employees. And the Consumer Protection Division has served cease and desist on many of SAF's vendors and businesses associated, in some cases accompanied by gag orders prohibiting them from discussing the CIDs with SAF or the public, potentially doing lasting damage to SAF and other CIDs recipients' businesses' relationships. For an extended period, SAF and CCRKBA were unable to communicate with its longtime accountants, only later learning that the accountants had gone silent due to one of the AG's gag orders. SAF and Mr. Gottlieb have been forced to expend hundreds of man-hours and over $100,000 in legal fees just responding to these demands, and there is no end in sight. Throughout this protracted process, CPD has claimed to be investigating unlawful conduct and enforcing the law. But in the 2 years of investigating, it has never identified any unlawful conduct whatsoever, nor asked or directed that any of the plaintiffs make changes to their practices. In fact, the CPD has never even been able to explain why it initially suspected any of the plaintiffs had engaged in unlawful conduct. Public records requests reveal, and CPD all but admits, that it has received virtually no consumer complaints regarding SAF or any other CID recipients. When pressed for information about what the plaintiffs are suspected to have done wrong or should be doing differently, CPD's attorneys have offered only a vague suggestion that some identified entity or entities associated with Mr. Gottlieb have not properly registered as a charity with the Secretary of State, or have registered but have failed to make complete disclosures with their registrations. Plaintiffs have examined their own records, reported back to CPD that they cannot tell what CPD is talking about, and requested that CPD stop being so cryptic and just explain what this interminable investigation is really about. CPD has provided no answer because it has no answer. As the months have worn on without any justifications emerging for the origin or continuation of CPD's comprehensive probe, it has become increasingly clear that CPD has never had any reasonable basis for suspecting any of the plaintiffs of violating the statutes listed in its CIDs, or any laws for that matter. Instead, CPD singled out SAF and Mr. Gottlieb for invasive and expensive harassment because of their political beliefs and activities, including their positions on gun control, their outspoken public criticism of Mr. Ferguson, and their legal challenges to his actions and policies. The other plaintiffs have been dragged into investigation because of their support for and association with SAF and Mr. Gottlieb's protected free speech activities. The agency's investigation is nothing more than a fishing expedition conducted in the hope of turning up dirt on the Attorney General's political opponents. The wrongful nature of these actions transcends politics. Regardless of one's policy preferences or partisan affiliation, the official misuse of legal process to pursue private vendettas and stamp out dissent is incompatible with a free democratic society. Defendants' actions are illegal and unconstitutional, and they should not be allowed. So put more simply, what the plaintiffs are alleging here is that Attorney General Ferguson, under the Consumer Protection Act, sound familiar? Because we've expanded the power given to the Attorney General over and over and over, has been investigating Alan Gottlieb and all of his organizations for no reason other than to harass and to suppress their political speech. This is something out of a third world banana republic, and this is the man who wants to be our next governor. Now, if you think I'm just over-exaggerating what's going on here, take a look at some of the other allegations in what the Attorney General's office did to the Second Amendment Foundation as well as several of its affiliates. The allegations include, by June 4th, 2021, CPD had obtained a gag order from a King County Superior Court that had the practical effect of totally preventing SAF's accountants from speaking with SAF, interrupting SAF's ability to timely complete audits of its finances. Apparently, CPD served the accountants with CIDs requesting sweeping information regarding SAF and Mr. Gottlieb and prohibiting them from notifying SAF or otherwise discussing CPD's demands. The legal authority for such a prior restraint of speech is unclear. Oh, but wait, there's more. Within a few months, CPD served similar demands and gag orders on an array of other third parties, including the essential vendors that make the activities of SAF and the other CID recipients possible. These included everyone from SAF's web host to the utility company that provides its electricity. That's right, the Attorney General essentially served subpoenas and discovery demands on all of these other privately held companies and issued gag orders so that they could not tell the Second Amendment Foundation that they were subject to this investigation. Guess what? There's even more, including, to date, SAF and Mr. Gottlieb do not know the precise number or terms of CIDs that CPD has issued to third parties. When pressed, CPD has bizarrely claimed that it obtained gag orders against these people and organizations for SAF's benefit, asserting that they had prohibited them from discussing the CIDs in order to protect SAF's reputation. This explanation is bogus, and CPD knows it. The CIDs and gag orders have themselves, as designed, severely damaged the plaintiff's reputations and ability to work with the third-party CID recipients, who could easily decide working with plaintiffs is not worth the legal bills and potential liability. And of course, one of the other things that really dictates between a tyrannical government and a true democracy is the amount of transparency that that government presents, okay? Can we actually go in and see how government is conducting the business? Well, what happened when the Second Amendment Foundation did a public disclosure request for records so they could figure out, hey, what exactly is it that you, the Attorney General, is accusing us of doing? And this is what the pleadings state. At a loss regarding CPD's motives, counsel for Mr. Gottlieb and SAF's attorneys submitted a Public Records Act request to the Attorney General's office on August 8, 2022, seeking all documents reflecting the origins and nature of the investigation and any allegations that have been made against them. The Attorney General's office still has not fully complied with that request, and still, nearly 9 months after the request was submitted, has not even given SAF a reasonable estimate of time it will require to fully respond. And of course, a tyrannical government would have its share of henchmen as well. Well, who's doing some of the dirty work here for Bob Ferguson? Well, it's one of the named plaintiffs in this case, an assistant attorney general named Joshua Studer. What is Mr. Studer's involvement in this? Well, according to the pleadings, it's as follows. SAF, interested as ever in fully complying with the law, promptly audited the registration status of all the Gottlieb-related entities that had received CIDs. On March 7th, SAF wrote back to Mr. Studer pointing out that each of the entities at issue was either exempt from registering with the Secretary of State under the applicable statutes or had in fact registered and made all required disclosures. SAF's counsel pleaded with Mr. Studer for an explanation. If your only purpose is to ensure compliance with the law, then tell me which one of my clients is violating the law which law they are violating, and what they are doing wrong, so my clients can address the alleged non-compliance. My clients have every intention of complying with the law as evidenced by the efforts they have undertaken to cater to your office's demand in this investigation. And how did Mr. Studer, on behalf of Attorney General Ferguson, respond? As follows. Mr. Studer never provided clarification of which entities he believed had not properly registered or what other unlawful activity he believed Mr. Gottlieb and the SAF had committed. Though Mr. Studer claims some identified entities had been violating the law for many years, he declined to provide any instructions on how they could bring their conduct into compliance with the law. Instead, he just pressed to set more deposition dates. Now, we're going to put a link for all of the pleadings down below in the description box, but what I want all of you to think about is after the last 12 years of having a governor who literally became intoxicated with power, who literally ran this state into the dirt with his own unfettered power, are we really ready to turn the reins over to a tyrant such as Bob Ferguson, who not only has demonstrated that he will run roughshod over anybody who dares oppose him, but he has abused the very powers given to him in the state's largest legal office? Listen, we're going to reach out to Mr. Fogg, the plaintiff's counsel, and see if he's willing to come on the channel and talk to us about this very, very exciting and yet disturbing case. The facts and allegations in here will literally make the hair on the back of your neck stand up, and it is something that every voter in Washington state needs to be aware of, because let us remember that Attorney General Ferguson has hitched his wagon to all of these gun control measures, and now we see how he has attacked those who have the audacity to speak out in favor of inalienable rights, and we also see how he has hitched his wagon to this assault weapon bill, which could very easily end up costing this state millions of dollars in unnecessary litigation. Listen, we will continue to follow this. This story is a long way from being over. And oh, by the way, if Washington gun law does disappear off YouTube, you will probably know why, because the Attorney General has come after us. Listen, in the meantime, if you do have any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington gun law by now. But if you don't, that's okay, because that information is right there in the description box. In the meantime, I need all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.